Hello and good evening to everyone joining us for this webinar on force majeure and contract disputes in response to COVID-19, uh, presented by Indian National Association of Legal Professionals, INALP, New Delhi, and International Law Institute, Washington, D.C. Uh, I would like to mention that we have received a very overwhelming response for this webinar in just 3 days, 400 above registrations, and I think we have around 100 people currently participating with us. My name is Manuj Bharadwaj. I'm the Executive Secretary of Indian National Association of Legal Professionals, for short INAL, and I'm a lawyer by profession. I hope you and your families are safe in these difficult times. About the webinar, I think the topic of today's webinar is very timely and important. ILI and INAP are partnering together with each other to lead thoughtful and important discussions on topics like this. I would like to briefly tell you about INALP and ILI. So INALP is a non-profit, non-political legal industry association which aims to capacitate the legal professionals of India. ILI is an international and leading knowledge providing institution that has been training various experts and has now trained more than 38,000 participants from over 186 countries through their technical assistance and training programs in the field of international law, economics, and international relations. The reason why this discussion on this topic is important because the global COVID-19 outbreak has disrupted all industries and has put a significant population of the world under lockdown. This presents the efficient working of business and has impacted existing operations and contracts. On the issues of contracts, this outbreak has brought many new aspects to the front, one of which includes the force majeure clause, and that impacts formal contracts. The outbreak and the rapid spread of COVID-19 has sent shockwaves to the global markets. It has disrupted supply chains, leading to the closure of several manufacturing facilities and units globally. And this has led to a decline in the overall volume of global economic activity, forcing the world economy towards a possible recession. All countries, including India, is suffering from because of this. The impact of COVID-19 on the world's economy and geopolitical alignments have been immediate and severe. From government-mandated lockdowns to supply chain stoppages to key industries being shuttered, all of these has led to substantial failures and delays in commercial contracts, performance of goods and services, monetary transfers, insurance claims, and many others. As the COVID-19 pandemic leads to the delay, interruption, and cancellation of many contracts, it is imperative for legal professionals and government sectors to understand contract disputes and force majeure provisions. Understanding how the contract has to be created, constructed, interpreted, and enforced in future and in cross-border boundaries is very critical. And for this, we have with us a very diverse panel of experts and speakers joining us from the far west to the far east, from Los Angeles to Singapore, from different time zones. We have Ms. R.V. Anuradha, partner from Claris Law, New Delhi, India. Anuradha advises governments and private sector on matters arising out of the WTO and free trade. She leads the team of her firm on climate policy. She has been recognized by chambers and partners and international who's of trade and custom lawyers. Welcome, Anuradha. We have Mr. Piyush Joshi, again from Claris Law. He's a partner there, and he's a specialist in projects and project finance. Piyush heads the legal teams of two major multinational companies, energy companies, including Enron and British Gas. He has been recognized by international who's who of the project finance lawyers as a leading practitioner in his field. Then we have from Singapore, Ms. Felicia Ten, Director of Litigation and Dispute Resolution at ESMP Law. Felicia is an experienced advocate specializing in dispute resolution with a focus on insolvency dispute and commercial disputes. She has worked with several big law firms and on high-level cases. Then from Paris, from US, we have Mr. John Marino, who is a partner at Crowell Moring in Washington, D.C. and practices international dispute resolution and litigation. We have his colleague from the Los Angeles office of Crowell Moring, Yao Mo. She is a member of firms antitrust and litigation groups. Then from Paris, we have Mr. Charles Narek, who is a partner at White and Case Paris office, working in the fields of international arbitration practice and also on the investor state arbitration. Then we have with us Mr. Zehan Trivedi, who's an associate at White and Case Paris office, working with his firm's international arbitration group. And prior to this, he has worked with various groups in London, Geneva, and Mumbai. So he has a diverse background. And I'm sorry if I've missed a lot of your introductions because we are short of time. So I think for the next hour or so, all the speakers will be sharing their insights, and will discuss force majeure and contract disputes from the jurisdictional perspective of India, China, Singapore, the US, EU, and others. All of these speakers will be sharing the provisions, perspective, and case observations from the jurisdiction they work and have the experience with. Then we'll move to the panel discussion, where I'll be asking a few questions to all the panelists. And then we'll take questions from the audience, which the audience can submit through the question and answer feature that we have on our screens. Now I would like to give the floor to the team of Claris Law, Ms. Anuradha and Mr. Piyush, to take the floor and to share their perspectives from an Indian side, and then we will go on with other experts. So over to you, Piyush.
Thank you, Manoj. As you rightly summarized, we are facing an extremely unprecedented situation worldwide, which will put to test the force majeure clauses that are usually found in contracts and the existing law on force majeure, particularly under Indian law. I would just like to give a brief overview of like a snapshot of the existing law. The force majeure clause, as everyone knows, is a contractual creation. It is governed by the specific terms of each contract, and so is the case in India. However, Indian law has codified certain specific points of the common law and deals and recognizes clearly frustration of contract. If a provision or a circumstance is not covered by the contractual provisions, it is going to lead into general law and result in the applicability of the Indian Contract Act and the provisions relating to frustration, which will render the contract to be void. The present circumstance, therefore, brings to sharp highlight what the contractual claims, what the parties had been working on, were there. Under Indian contract, it is very well recognized that the parties are free and capable of formulating a force majeure provision, which will then bind them to the very specific events that they have agreed upon and the very specific steps that were agreed upon. The COVID-19 situation, in our experience and our practice areas, span from energy to urban infrastructure in the project finance space. In the last few weeks, we have been really looking at all law firms that the force majeure provisions are entered into by the various clients. And what our finding is that, unfortunately, the concept of the standard contract or the standard force majeure provision is going to be put to test under Indian law to these present circumstances. This is because most clauses have been drafted keeping in view that there will be an affected party, and the affected party has been imposed certain obligations, including immediate notification of the force majeure event, and the fact that the force majeure should have been unforeseeable by a reasonable and prudent operator, or somebody who is acting as a reasonable and prudent operator. This brings into sharp focus what is foreseeable, what is unforeseeable, and that will be determined by the facts of each case. Under Indian law as such, it is totally again up to the parties to have documented their requirements or their agreement in this regard, which, as usually even in large contracts, given by the government of India, the model force major contract, is insufficient for the particular circumstances we are facing. And the reason is that in these circumstances, it is not just COVID-19 which is causing the issue, but these are directions from the government of India. Because unlike various jurisdictions where there's some element of voluntary adaptation or adoption of the lockdown, under Indian law, it is a direction under applicable law which carries penal consequences. And therefore, it is a direction coming from the government of India, which is causing the series of events and circumstances where all contractual parties are finding themselves. The change in law provision in most clauses do not contemplate such event, and they're mostly weak in the sense they allow the parties to just meet again and amend the contract. But the force majeure provision has been drafted in a manner that clearly contemplates only one party to be an affected party and the other to be somewhat or a non-affected party. However, in the present circumstances, the same party may be non-affected party at the beginning of the transaction or when it receives the notice. But within a few weeks or even after a few months, it may become an affected party. And therefore, the conflicts that will arise as to its rejection at one point of time at the beginning and then declaring itself as an affected party under the force majeure at a later point of time will have to be tested. In this regard, I would like to take the snapshot of the natural gas sector, and I find the natural gas sector to be a good example of how various sectors in infrastructure as well as general economy are facing the present situation and how they have landed in a situation where they need immediate support. So I hope everyone can see the slide I have put on the screen. And this specific is to reflect on the fact that the natural gas sector, and I'd just like to take 5 minutes to explain the slide. The natural gas sector in India can be stratified into upstream, midstream, and downstream segments. And the upstream is the segment where the companies have got awarded concessions from the government of India to actually undertake drilling and oil exploration and exploitation rights. And only about 40% of India's natural gas demand is currently met by Indian extracted natural gas. 60% of India's natural gas demand as of March 2020 came from imported liquefied natural gas. And liquefied natural gas is, as everyone would know, is coming from long-term contracts, medium-term contracts, and also on spot basis. The impact of the pricing due to the COVID situation has occurred at the spot market level. And therefore, the Indian bulk gas suppliers, who are the aggregators of the liquefied natural gas, are faced in a situation where they have committed to long-term pricing for pricing stability, but at the same time want to take advantage and are faced with a spot price, which is very lucrative. But what has happened is that there has been a contraction in demand. The gas transporter, who is the midstream, is the pipeline company who has connected the LNG terminals and the upstream operator across the country with various pockets of high consumption of natural gas, which could include cities or industrialized zones. And gas transporters have been, till now, in siloed form, taking contracts which only demarcate the specific risk that they are willing to take or they're capable of accepting, as should be the case. And which is only of having built the pipeline, they have the capacity to give, and that capacity is taken on long-term contracts, and there's certain capacity available on short-term contracts. And that capacity is utilized by Indian bulk gas suppliers, as well as the downstream component of the Indian gas sector, which is the city gas distributors. Under Indian law, the city gas distribution contracts are regulated by a regulatory authority and they are given out through a competitive bid process. Therefore, the city gas distributors are themselves working within a regulated framework and their activities are also monitored under a regulatory framework. The city gas distributors have an exclusivity for a period of 5 years to or less, depending on the terms of the license they obtain, over consumers having less than 50,000 SCMD of demand. So that we are talking of is a bulk of industries in India, except for the large scale consumers, which are your fertilizer industries, power plants, and petrochemicals and steel plants. So what we have in the Indian gas sector is a clear stratification, and therefore the contracts represent the allocation of risks that have so far worked and worked very well, with the bulk gas suppliers accepting the risk of the LNG SPA. And the LNG SPA is governed mostly by English law or the US law, depending on the jurisdiction from which the LNG is being imported. And it has corresponding contracts with the LNG terminal, which is a port, which is obviously located within a port, and therefore regulated by the port sector regulations as well as the petrochemical regulations. The gas transporter has siloed himself with the specific contracts relating to capacity usage and capacity marketing. And the city gas distributor has taken the risk of the absolute downstream sale and distribution of gas. Now, with the COVID situation, as the slide is explaining from the left-hand side, the blue arrows are representing the flow of notifications, while the red arrows are going to be describing the disputes. So the government of India has given notifications which are not challenged, and it is the only entity in this whole web which is not being challenged as of now. And this is the government of India's notification under 2 statutes, declaring that COVID-19 is an epidemic and therefore they're declaring a disaster. And under the Disaster Management Act are directing that all economic activities should be shut down other than the ones specifically exempted. And they have identified those specifically exempted services or industrial processes. Therefore, the rest of the economy, which will include your manufacturing segments, commercial establishments, transportation, export-oriented consumers, have all had to shut down within. And no contract has been ever structured to provide for an unplanned shutdown within 24 hours, which is not otherwise foreseeable, and therefore the force majeure clauses become the only framework within which you can look at relief for the buyers or the commercial establishments who have had to undertake the shutdown. Now, the shutting down of the various segments of the economy have resulted in either reduced operation or shutdown of the primary consumers, which is fertilizers, industries, power, petrochemical, steels. And they therefore have to pass on that force majeure to the gas transporter, to the city gas distributor, or the bulk gas supplier, depending on where they are getting the gas supplies and with whom they had contracted for the capacity for obtaining the gas from the pipelines. Now, this presents a unique challenge because the Indian bulk gas supplier has not ever been faced with the situation of shrinkage of market. Indian LNG imports have always been increasing ever since India started importing gas in 2008, 2005 onwards. The upstream operator has been struggling because the volumes of natural gas which are being found in India have been reducing steadily, and production as of March had reduced by 14%. But it is the cheapest source of gas in India until mid-March of this a few weeks ago. And as the cheapest source of gas, it again never faced a situation where the market has disappeared overnight. And therefore, we are
Piyush,
all faced in a situation where the city gas distributor is issuing force majeure notices to the gas transporter. The gas transporter is immediately rejecting the force majeure notice, stating clearly that either you have not given the notice in accordance with the particular framework, and therefore the contract has not been satisfied, and you have issued something outside the contractual framework. The gas transporter has to immediately issue a force majeure notice to the upstream operator, because due to the massive reduction in gas offtake, the pipeline is full with what is technically known as the line pack. That is, there's unmoved portion of gas, and therefore there's high pressure in the gas pipeline, and it cannot intake any further natural gas from an operator, upstream operator, who has to continuously undertake the operations, because the Government of India notification says all petroleum and natural gas operations are essential services and they have to continue. Therefore, if the gas transporter cannot shut down its pipeline, it needs to allow the gas to go off somewhere, but there is no place for it to go. Therefore, it is declaring force majeure, or it will eventually have to declare force majeure to the Indian upstream operator who has reserved capacity in its pipelines. Similarly, the gas transporter will have to issue a force majeure notice to the bulk gas supplier at some point of time if its pipelines operations do not normalize. The Indian
Piyush,
bulk gas supplier.
can I interrupt for a minute?
Yes.
Yeah. Thank you very much, for explaining us through and taking us through the energy sector and how these contracts are disrupted because of the demand of the gas and everything. May I also request, if Anuradha can add on her experience and what she is experiencing right now in this particular issue, regards to this issue of force majeure, and what are the, if there is any order by any court, like High Court or Supreme Court of India on this, and if she can share her views on that. I'm so sorry, I have to keep interrupting all of you because of the time issue. So if Anuradha can pitch in and can share her views on this.
Yeah, can you hear me?
Yeah, we can.
Yeah. So just to pick up from where the Piyush what Piyush was talking about in terms of the snapshot of the gas sector, I think it's just fascinating because this is one sector where there are multiple parties at different points of the entire supply chain. And at any given point of time, each one is going to be an affected party because of this situation. And the point that he was essentially trying to make is that we are going to be dealing with a complex set of circumstances. This is just an example of how it's impacting the gas sector. But similar situations are likely to arise across sectors because there is really going to be nobody which is unaffected by COVID-19. So in a sense, this is really an act of God for everyone. And how are concepts such as force majeure or frustration or change in law, material adverse effect, which are legal concepts for which there is existing jurisprudence, are they enough to deal with this, is something which we'll have to wait and watch. To quickly move on to circumstances, Piyush was dealing with a situation where contracts provide for force majeure. And he was talking about how this is going to be acted upon by each of the affected parties. But what if there is a situation where contracts are silent and they really haven't envisaged a force majeure clause or a situation? The Indian Contract Act that, as Piyush mentioned briefly, has codified the concept of frustration. So we have a very simple provision in the Contract Act, which essentially says that an agreement to do an act which is impossible is in itself void. So it also envisages agreements which, having been possible at the time of being entered into, subsequently become impossible. But the threshold of impossibility that has been interpreted by the Indian Supreme Court, as has been the case under various English cases, is fairly high. So for example, the Supreme Court has said that the term impossible, as used in Section 56 of the Contract Act, is not used in the sense of physical or literal impossibility. It also acknowledges that if there is an untoward event or a change of circumstances that totally upsets the foundation of a contract, it can be said that a party may find it impossible to perform what it had promised to do. But at the same time, courts have been very careful. And they've noted that a party is not discharged from performing an obligation merely because a contract becomes onerous. So in other words, when a plea is being made, when a notice is being issued to a counterparty under a contract, whether making a case for frustration or force majeure, as the case may be, it needs to be done with tremendous care and consideration of the terms of the contract and the circumstances under which the contract was entered into. Because the burden on the affected party would need to show that the parties never agreed to be bound in a fundamentally different situation. And how is it that COVID-19 has resulted in something which was totally unexpected, which is impacting something not just for a temporary period of time, but has altered the circumstances substantially. Contracts need to be evaluated for various other provisions. Piyush briefly mentioned the concept of change in law. So there are provisions dealing with force majeure that could be there in a contract. There could be provisions that deal with change in law. The government notifications that he mentioned clearly constitute a body of government orders, notifications that have altered the legal scenario. So that needs to be taken into account. A number of circumstances, number of contracts which also provide for material adverse effect or material adverse changes arising out of certain circumstances. So when issuing a notice in relation to a contract, care should be taken in terms of under which clause of the contract a party is going to proceed under. And if the contract is completely silent on any of this, and if the party seeks shelter under the overarching concept of frustration, equally the same due diligence and care needs to be taken to meet the fairly high threshold that Indian courts have put forward. The point of the matter is that we're dealing with a variety of different situations, different contracts, different issues. It is unlikely to be a one-size-fits-all situation that can explain the entire gamut of circumstances. And already, Manoj, courts in India are seized, as you're aware, they're seized with several matters. There appears to be some diversity of opinion in terms of how this should be approached in recent orders that have been passed by the Delhi High Court and the Bombay High Court. In such a circumstance where the Supreme Court have to step in, there was one commentator who mentioned that there's just going to be a tsunami of litigation. So we're really envisaging a situation where parties are not only dealing with the after effects of COVID-19, but are now going to be dealing with the litigation impact of COVID-19. So what could really be an ideal solution? You know, one of the examples that commentators have been talking about a lot is the Singapore solution, which, you know, and it'd be nice to hear Felicia's views on that. Singapore's Temporary Measures Act, which came into effect, I understand, in April 7th. It's been a month now, which actually provides protection from various circumstances and various contractual consequences, such as payment of damages or enforcement of security and such like. In India, of course, it would be difficult to have an overarching law across sectors, especially given the federal structure and the fact that the states have jurisdiction over a variety of subjects. But at the same time, there are ways to, of course, achieve it, as you're aware. And it would be interesting to see whether a legal solution can arrive at some more of an equity or an equitable situation to address this completely unprecedented set of circumstances. And keep it short and then, you know, leave it open for discussion.
Sure. You said it very rightly that one solution can't fit all type of situations and problems. So there's a lot of brainstorming that needs from the side of government to fit in, resolve these issues. And obviously there will be a lot of litigation, and to prevent that, we have to learn from the best practices and also the dispute resolution for these kind of issues. And as you rightly mentioned about the Singapore solution, so let's hear it from Felicia and what she has to say, as she is working in a lot of other jurisdictions also, like China and Cambodia. So Felicia, could you please share with us your views and perspectives on this?
Thanks, Manoj, and good afternoon, good morning to everyone wherever you're dialing in from, and good evening to myself. So thanks for the shout out about Singapore. I am going to just share my screen to show you some of the materials myself and some of my friends in China and Cambodia prepared. So I don't take credit for all the material that you will be seeing. Quite a bit of it is not my own. just let me get to share that. But so I will start by giving you a broad overview of what force majeure provisions are like in Singapore, what the law about it is in Singapore, before I get to the COVID-19 Temporary Measures Act 2020, one of the longest names we have for an act, and it's a mouthful, but it's quite necessary for now at least. So let me just put that in the background for you so you can read it as and when you need to. I won't be reciting this to you, it just wouldn't be helpful. So long and short, I think for tonight, most of you will hear similar views from the rest of our panelists, which is, I think most of our jurisdictions do not have a fixed definition for force majeure, at least for most common law jurisdictions, we don't, because force majeure clauses are deemed as a contractual allocation of risk. So parties agree what for your transaction, what force majeure should mean. And that has been how the Singapore courts have interpreted force majeure throughout the years. Of course, so it does create a situation whereby the more well-advised clients' transactions do tend to have a lot more specificity when it gets to force majeure events. And the less well-advised ones tend to have a very broad or vague or ambiguous definition, and then require a lot of assistance at the end of the day from the court's interpretation. But our courts tend to be very, so they're very slow to imply any event into a force majeure clause if it's not expressly provided in the contract. So there are two schools of thought, right? Some say perhaps if you are poorly advised, it might end up being better because you draft it so broadly that it captures almost all. And you could say that the intention of the parties was to capture very many types of events. Whereas a very heavily negotiated contract, I did one recently for a construction, not really construction, more infrastructure contract for a district cooling system, and the negotiated force majeure events went, I think, into 36, and it wasn't even an exhaustive list, it was an inclusive list. So it was these examples of these 36 plus more. So in the latter situation where you have a very long illustrative list of events, the court is likely to then be less likely to imply any further events. The point would be, parties have spent so long negotiating the contract, surely they know what they intended to allow the contract to be terminated because of force majeure or delayed performance because of force majeure, and what they are not likely to allow. So that's very clear. We're very much driven by contract. So would the COVID-19 be considered a force majeure event? I think right now the difficulty is this. We have a slight slowdown, I think, in terms of published jurisprudence from the court, because since I think the 6th of April, our courts are now only hearing essential and urgent matters. So there has been a slowdown in actual cases being brought to court. So you only have my words and my peers' words as to what would amount to force majeure. I think if the contract made it clear that there was any particular epidemic or catastrophe, I think it would be considered, very likely considered to be a force majeure event in Singapore. But I would say I echo my colleagues from Claris Law's comments earlier that that's not the be-all end-all. That's only the starting point of the whole analysis, whether the event was a force majeure event, because you then need to see whether the force majeure event had any effect on your ability or your counterparty's ability to perform the contract. Otherwise, that's just like saying we're all living through the same event, but it has no impact on your contract, then you don't get the protection. So that's, in a nutshell, the Singapore position. So my friends in China and Cambodia and a couple of other jurisdictions, we were all asked the same question about force majeure certificates. I took that question and put it in my slides because I thought it was an interesting question. Most of us in Singapore, before I saw this from China, I never thought there would be an authority that would issue a certificate to say, yes, this has been, this is a force majeure event and it's official. But so there is an authority in China that does that. Singapore does not have that practice. But as mentioned, on the 7th of April, the Singapore COVID-19 Temporary Measures Act 2020 was enacted. The actual relief, because the act was actually very all-encompassing, it included the things that keep me from entering my office now. So the subsidiary legislation called the Control Order subsidiary legislation to this act prevents me from going in because legal services are not considered essential services in Singapore, sadly. There are slight limitations if you are prosecuting or defending a criminal trial where the penalty, it's a severe penalty, the punishment involves death penalty, or the accused person is in remand, or limited situations, yes, then that's essential, but the work I do, not essential yet. But in any case, so the specific relief only came into force from the 20th of April, so that's less than 2 weeks ago. And it will be around for 6 months till the 19th of October. Now, what does this temporary relief do? So for certain scheduled contracts, so there are 5 categories broadly. For these 5 types of contracts, you can put up and file a notification to seek relief on the basis that you believe your contract has been affected by COVID and cannot be performed the way it should be performed. So these would be your leases and licenses. So it's very common that obviously, you can't go into your office or you can't lease. There is a side conversation, anyone's interested later, about co-working spaces and whether that's considered a lease. But so if it's a traditional lease, you're safe. That's considered one category. Construction and supply contracts, that's one. Secured loan facilities is a third type. Hire purchase agreements is the fourth type. And an interesting type I thought might be worth sharing is event and tourism related contracts, obviously very affected by the lockdowns in various countries. So these 5 types of contracts, if they were entered into on or before the 25th of March, and they were to be performed after 1st February, then you're entitled to file a notification to seek relief. Now, obviously, we are expecting perhaps a volume of cases. It's not cost friendly for individuals to go to court or entities to go to court to get the notification adjudicated. So private volunteers, myself included, from the legal industry have signed up to the Ministry of Law as appointed assessors. So we assess based on the notification particulars submitted to us whether the contract has truly been affected by COVID. And the test we're told is whether it was materially affected by COVID. All lawyers on this call will know the two words, or the one word material in and of itself is the subject of years and centuries of debate and scholarly articles. So I won't get into that. We all know what the problems with that will be. But I don't think it's a problem that we can avoid, because if we allow it to be any contract that is in any extent affected by COVID, then you would open a can of worms. Everyone would try that. So that's one of the tests. The other thing, of course, is if we looked at the old jurisprudence from the courts before COVID, so my hunch is what would be considered materially affected contract will be something whereby perhaps not as much as saying that the contract could not be possible or impossible to perform, but commercially so impractical that it would have defeated the original intention of the contract. So we have had cases which one party argues that the cost has gone up so high it's not practical, and the other party says, well, the cost has gone up a bit, so it's eaten away at higher margin, but it's not like you can't perform it. It's just meant that you just made a neutral transaction. So in such a case, it's very likely that the court will say there was no material effect, right? And so for now, I'll leave it here because I still want to quickly get through China and Cambodia, bearing in mind the time, and I'll be happy to take questions later. So I've dealt with that. So okay, again, credit to colleagues elsewhere in Cambodia. So likewise, in Cambodia, I understand there is no clear definition of what constitutes force majeure. But if you rely on it as an implied term, so that's interesting. In Singapore, you couldn't imply force majeure into a contract. That there is no possibility. Whereas in Cambodia, it's possible, though the test might still be difficult because it's limited to certain types of contracts like leases. And you can only terminate a contract after what I hear is 3 consecutive years of force majeure. Hopefully we don't ever get to see 3 consecutive years of COVID. So next, sorry, that was too quick. More about the Cambodian situation. Like in Singapore, there is no authority that will issue any force majeure certificate. So there isn't any particular confirmation. It's left to the courts. And yes, I'm going to leave the rest for you to read if and when necessary. For China, like I mentioned earlier, the China Council of Protection of International Trade actually has the recognized authority to issue force majeure certificates. So that, in a sense, what I would say is one step probably more, one step further forward looking than even the Singapore COVID-19 Temporary Measures Act, because ours is done by private assessors, although we're volunteers, but the system is run by the Ministry of Law, but you're not getting a direct certificate of force majeure. You're getting a temporary relief for 6 months. That's quite different from saying force majeure has applied. So again, I think that's I personally think that's a good move from China. And they also have, they have a definition, unlike the rest of the common law world. There is a definition in the general rules of the civil law of PRC, where force majeure means an unforeseeable, unavoidable, and unconquerable objective situations. I'm sure that in and of itself, that definition will also attract a lot of scholarly debate as to what is an unconquerable objective situation. But I will again leave that, and as with a lot of, I'm sure I'm happy to take questions later. And as for whether COVID-19 is considered a force majeure, I think personally, I think in most countries, if there was any doubt, I don't think there would be a doubt in China. But I think I get back to the same point I started with. I believe in any jurisdiction we get to, this is only the first step of the first part of the question. We still need to see whether force majeure really impacted the transaction that you're talking about. And on that note, I think I'm at the end of my slides, and I'm happy to hand the mic back over to Manoj.
Well, thanks, Felicia. You have given an overview from various jurisdictions, and I believe before this pandemic, I think force majeure was an important clause in the contracts, but we never thought of that this particular clause would be so important after this unprecedented condition that the disease has posed in front of us. So what you mentioned, that I can gather from it that there in some countries there are authorities, those who are issuing certificates and reliefs that okay, it's a force majeure condition, and then you can have a 6 months relief on that on your contract, and also to measure the impact of the COVID-19 on your contract, and again the authority, and I was surprised that in Singapore the legal services are not considered as an essential services, though it can lead to a lot of failures of contract, because obviously all of us get into contracts with our clients. So this was very interesting for me, and I think the gravity has to be understood, like up to what level this COVID-19 is affecting a contract, and then again there's a need of a lot of discussions, and by also the precedents set by various courts are very important in this aspect. So now I would like to move on to my colleagues from our panel panelists from Washington DC and Los Angeles, from Crowell Mooring, John and Yao. So I would leave the floor to John, and then Yao can also join and then can share your perspectives. Yeah. Thank you.
Thank you, Manuj. Thank you very much for having us, and good evening, good day, good morning to all of our colleagues on the line. In the U.S., like many other jurisdictions we've heard about already today, there isn't a set definition under the common law system of what constitutes force majeure. It is very much a ugliness in the eye of the beholder, and is determined by the facts of the event, what's causing the business disruption, the contract itself between the parties, and the jurisdiction's law. This can be very complicated in the US because this sort of question is determined under state law. And so there could be 50 plus different answers depending on where the parties all reside or where the contract is being performed. And there could be some disagreements on which state's law would apply to the circumstances and to the contract. And so all of these issues are issues that, if taken to the full extent, could be sub-arguments regarding the business disruption at the core of the fight. So these are issues that can be very complicated, some of which can be cured or can be addressed if the contract is drafted properly. Now, obviously, examining the contracts after the event has occurred makes things more complicated. But one thing that Yao and I have noticed is we have a number of clients coming to us now saying, in light of the pandemic, in light of what we're all dealing with now, should we change our contracts going forward? Or if we're receiving new orders going forward, do we need to address certain contract provisions to make sure we are capturing the events of the pandemic or whatever is the next pandemic or something similarly situated? So it's both legal questions regarding what are our rights right now and what we're dealing with, and then now going into the future, how do we pivot, how do we adjust in order to capture things going forward? And as you'll see in a bit, why that's very important is because one of the fundamental concepts under US law, generally speaking, no matter which state we're talking about, is the foreseeability of the event. If the event is unforeseeable, force majeure may provide protection, including if it's referenced in the clause or not. If the event is entirely foreseeable, then the parties have a much more difficult argument to make whether that event should alleviate their performance obligations. So the first thing we look at when we're considering the business disruption is what exactly is the event causing the disruption? Is the event the pandemic itself? Is the event the government response to the pandemic? Is the business disruption labor shortage as a result of the pandemic? This is all very important, and under US law, you need to look at what the notice describes as the cause of the business disruption. One of the things that Yao and I have noticed is some of our clients have received notices. The notices reference COVID-19, of course, but then they go on to describe the reasons for the disruption, and they are really undermining their own claim of force majeure because they reference things like lost profits or increased costs having to do with certain inputs. These are all things that undermine force majeure notice in the US because simple lack of profitability or change in the value of the contract are not grounds for force majeure, generally speaking, under US law. What is required under US law for something to be forced to have protection under a force majeure clause is that the event is either covered in the contract or is covered by a catch-all phrase within the provision in the contract, and I'll go into that in a second, that it's unforeseeable, and that it actually prohibits performance of the contract, not simply makes the contract performance more difficult. That's a key distinction because we have noticed clients dealing with situations where their counterparty can still perform the contract, it just is a bit more difficult. They have to hire another ship, they have to go in a different route, they have to go to a different port. These are all circumstances that under US law do not necessarily rise to the level of force majeure, even if your counterparty is claiming force majeure. So it's important to look at that notice and then really examine what are the underlying circumstances requiring or forcing the business interruption. Another example would be this. If there is you have to perform a contract in a certain state in the US, that state may not have actually shut down that business, may not have prevented that factory from making that device. It might have been deemed essential. So if you are receiving a notice from a company within that jurisdiction, you need to actually check, are the circumstances such in that jurisdiction that they're actually not able to perform? The answer may be, once you do a little checking in it, well, actually they are able to perform. And we've seen some of those instances come across our desk too. There could be American companies, there could be non-American companies. It's important to check the jurisdiction of the company claiming non-performance, the inability to perform, to see then, okay, are they able to perform and it's more difficult, or are they not able to perform? And then you look back at the contract language to see if things are covered, or to see what is the standard that that party is going to be held to. After you review the the individual circumstances preventing performance or causing the business disruption, the next thing you're going to want to do in the US is really look very closely to the provisions of the contract. Many contracts that are drafted in the US have a litany of excuses or reasons why a force majeure event has happened and to offer protection. There are different ways of interpreting that clause, however, and it really depends upon which jurisdiction you're in within the US regarding whether and to what extent you'll receive the benefit of the doubt, or to read that clause as broadly as possible. In certain jurisdictions, and I note New York in particular, when you have a clause that has a litany of reasons for protection under force majeure, and I'll give those as acts of God, tsunamis, earthquakes, they'll then, the litany will include things like, may include things like riots, labor shortage, things of that nature. That will be important what is in that litany, because in New York, when there's a catch-all phrase at the end of a clause that says, or any other circumstances that are similar and not within the power of any of the parties or either of the parties, the clause, that catch-all provision will be read in light of the types of events that have been mentioned previously in the clause. So if the types of events that have been mentioned previously in the clause are all what may be thought of in the US as acts of God, then there may be one answer to whether you receive force majeure protection. If there include items like labor shortages or shortages of supply, those might not be thought of as acts of God. If they're included in the litany, you may have more protection. If the only thing that is in the litany of reasons for the force majeure protection are true acts of God, then certain of the business interruption characteristics, reasons, will cause that business interruption not to be protected. So it's very important, you must dig into the actual cause, not something general, especially if that actual cause is not part of the litany of reasons given in a force majeure provision to provide protection. Next, you'll also want to consider exactly what does that clause protect. You have to look very specifically. Does it provide protections for the party who's claiming a force majeure event? In the US, and we've seen these notices come across our desks in the past 2 months now, the party claiming force majeure protection, once you look at the contract provision may be entirely protecting only the seller and not the buyer. So the buyer does not have any protection under the force majeure clause in the contract because they bargained and didn't bargain themselves into protection. In that instance, if a buyer is looking for protection because they're not able to perform their obligations under the contract, you have to resort to the common law. And Yal will address the common law in a moment for you all. But think of it as, in the US, I'm looking at, if I'm unable to perform, the contract itself. I've examined the event and determined whether all the reasons for the event that are actually causing the business disruption. Then I'm looking to my contract to see what protection it provides, who it provides it to. That is very important, who the clause provides it to. Now, if the clause does not provide me protection, am I out of luck in the US? The answer is no. You may still have protections. You're going to resort to the common law and concepts like impossibility, impracticability, or frustration of purpose. Y'all will discuss those a bit more in a second, but you're not out of luck if there isn't a contract provision, but it is a bit more difficult and you have to do more study and more analysis. The last thing that you'll want to consider when you're looking at the force majeure clause is exactly what does it give the power of the party to do? Are they able to suspend performance or are they able to terminate performance? The clause itself, if drafted appropriately, should be explicit about that. It will give the party who claiming the force majeure event, and there may be some disagreement about whether that's a force majeure event or not. However, it should be clear and plain in the language Are they able to terminate performance, or are they able to suspend performance? There are some provisions that allow for termination of performance or suspension of performance. And then there are other clauses that allow for suspension that may eventually develop into termination. Each of those scenarios will be interpreted by a court in the US. There isn't any authority that's going to provide certificates in the US. So these are issues that need to be worked out by the parties or not worked out by the parties. And if they're not worked out by the parties, then they're forced to go into court to protect their rights. There isn't an overarching authority that is going to provide a certificate that does happen in some other jurisdictions. Now, there may be some official declarations of some jurisdictions that are useful, like a declaration in a particular state that there is a pandemic, or like a declaration from a governor of a certain state that certain businesses or certain activities cannot happen. So for instance, although you're not going to receive a certificate in the US, if you reside in, or the contract calls for performance of a large event in a particular jurisdiction where that governor has declared that events of more than 10 people cannot take place, that's not a certificate, but that is clearly going to establish a cause for the business interruption, because literally the contract cannot be performed under law. So that is very useful then. The last thing to mention, going back to termination and suspension, is in the US, the parties have to be careful to be transparent about the communication. There are obligations on a party receiving notice of force majeure to mitigate their damages. And so a party will only know to mitigate their damages if that party understands how long performance is going to be suspended for, or is it going to be suspended or terminated. If the performance of the contract is going to be suspended for 1 month, and it's a contract for the supply of goods, the recipient of that notice cannot go off and purchase those goods for the next 9 months if the suspension of the force majeure event was only going to be for 1 month. So it's important to be transparent in your communication with your counterparty, and then for the counterparty to follow up on that notice, asking questions when they're not sure, and being clear that being clear about what is expected between the parties. There are duties and obligations on both sides of a force majeure event, whether you're the noticing party or you're the receiving of the notice party. And so there are strong reasons for a party receiving a notice to reply, ask more questions, lock in the one side about what exactly is the real cause of the business disruption, and what is their understanding about when they are going to be able to start performing again. None of these questions and answers require the other party to agree with the answers, but you're certainly better off knowing what your party is saying is the reason. Another practice point on this is because it prevents your counterparty from changing the reasons later, having resourceful lawyers who are thinking through these issues 18 months or 2 years after the event and coming up with other reasons. You really want the party who's declaring force majeure to explain themselves in the moment. And then later there can be evaluations about whether that was appropriate under the contractual provisions or not. But you don't want them to be able to be explaining their behavior months and years after the fact to seem more reasonable. You want them locked in the moment to be clear about what the reasons are, and then there could be disagreements about the contract going forward at a later point. At this point, I'll turn over to Yao to discuss if the force majeure event, again, we talked about what is the actual cause, and then what does the clause say. If you get to the point under US law, wherever the jurisdictions are, where the event is not covered, or there is no force majeure provision in a contract, does that mean that the party is bound to perform or else be liable for damages? The answer is no. You then turn to a backdrop of common law principles that may provide protection. Yao, please.
Thank you, John. So this is Yao from LA. So I want to talk about what happens if a contract does not have a force majeure clause. The parties may rely on two doctrines, the doctrine of impossibility and the doctrine of frustration. And I'll first briefly talk about the doctrine of impossibility. Almost all jurisdictions in the US recognize the doctrine of impossibility. Now, under this doctrine, a party's non-performance may be excused if the party can establish three conditions. First is an unexpected intervening event occurred. Second, the parties' agreement assumed that such an event would not occur. And third, the unexpected event made contractual performance impossible. Now, some jurisdictions, such as California, where I practice, the doctrine of impossibility has been expanded to include impracticability. Now, this means that non-performance will be excused if the performance under the contract requires, and I quote, excessive and unreasonable cost. Now, another doctrine that a party can rely on is the doctrine of frustration of purpose. Now, under this doctrine, a contract may be terminated automatically if a so-called frustrating event has occurred. And this frustrating event must be unexpected and must be beyond the party's control and must make the performance under the contract impossible or radically different from what the parties contemplated when they were entering the contracts in the first place. Now, frustration must be significantly, must be changing the nature of the outstanding contractual obligations or rights. It is not enough if an event just makes the performance under the contract less profitable. So the key question to ask here is really, does the COVID-19 outbreak or government actions in response to COVID-19 or some other related circumstances render contract performance impossible, impractical, or radically different from what the parties contemplated when they were entering the contract in the first place? If the answer is yes, then a party likely has an excuse for not performing under the contract in the US. Now, the next question becomes, what steps should a party make if it is considering invoking force majeure clause or other related doctrines that I just talked about? And I would like to share just quickly 3 practical points. So the first tip is to be really thoughtful about all the communications with a counterparty. Be clear regarding what is impacting performance and whether and how performance may be resumed. And the second tip is to take note of any notice requirements specified in a contract. If the correct notice is not sent in the specific time limit under the contract, then there may be an argument that the force majeure defense is waived. And the third point is to review the dispute resolution clause in the contract and consider what actions may be possible under that contract. In many cases, John and I have seen invoking force majeure or other related doctrines is really just the beginning of the dispute. So parties need to consider, documenting and preserving all communications with a counterparty, especially regarding the reasons for invoking force majeure or other related doctrines. And also avoid statements to counterparty that could undermine their arguments in the future, our arguments in the future. And also, of course, maintaining attorney-client privilege for internal communications. And the last point I want to share is that invoking force majeure and other related doctrines in one contract does not necessarily mean that it does not necessarily affect all of the company's other contracts. Just as John mentioned earlier, it is a very fact-dependent analysis, and it will vary from jurisdiction to jurisdiction. And that's all I have to share for now.
Thank you, Yao. Thank you so much. It was I think the points you have mentioned and what John said about like how the contract can be performed or non-performed, or like it can be terminated under various circumstances. The points, the provisions that you have mentioned, and what you have said in the end, like the points that all communication should be preserved with the parties, notice requirement, and dispute resolutions. Because I think dispute resolution is also very important in this case, because there, as Anuradha in starting mentioned, that there will be a tsunami of litigation. So I think let's hear it from the people from Wyden case, the team from Wyden case, and what their experience is, since they are dealing with various jurisdictions, including the EU, and what they think about, and also if they can give a bit of perspective from the dispute resolution of this issue arising around. So over to you, Charles and Zehan.
Thank you very much, Manoj. So my name is Charles Nerak. I'm sitting here at home in the outskirts of Paris, and my colleague Zehan Trivedi is an associate in our group, sitting also at home in Paris. So by way of introduction, I want to clarify that even though we work and live in Paris, in fact, we work on international arbitrations really all over the world. Paris is, of course, an important center of arbitration, which is why we have a big arbitration team here. But most of our cases really bear no relation to France or to French law. In fact, we regularly have cases under a huge variety of different applicable laws. And that's the perspective that we wanted to contribute today in this world where borders have taken on a whole new meaning. We like to think that our international arbitration world is still a world without borders. Now, let me try and share my screen, and please confirm that this is working. You should be seeing the first slide of a short slide deck. Do you see it?
Yeah, it's working.
Wonderful, thank you very much. So, by way of introduction, sorry, I'm trying to pass the slides. Here we go. Through our experience working on a wide variety of cases under a wide variety of applicable laws, what we see is that there are considerably more commonalities between different systems of law than there are differences. And in fact, everything I've heard so far on this call really confirms that finding. There are certainly some differences in some details, but at the end of the day, the principles are very much the same. In fact, after 25 years of practicing law in a number of jurisdictions, I find that the big difference between common law and civil law, for example, is not so much in the law as in the brain of the lawyers who practice it. But that's a debate for another day, maybe. What do we see in terms of common threads? We see that in most legal systems, I want to say all legal systems, what the legal system wants to do is to compel the parties to enforce their contractual bargains. There are some exceptions here and there, mandatory provisions, etc. But that is the philosophy of all legal systems. Usually there are very limited grounds that will allow a party to be exempted from contractual performance, and the burden of proof and the standard of proof in order to achieve such exemption is usually very high. Now, in this presentation, we've chosen to use French law and English law, with which Zehan and I are familiar from our practice, as proxies to illustrate the approach of civil law systems on the one hand and common law systems on the other in the specific context of the COVID-19 pandemic. So maybe by way of a further introduction before we get into the legal issues, what are the sort of situations that we are facing right now since the pandemic started a couple of months ago? We are getting a lot of queries from existing clients, from new clients involved in projects all over the place that are inquiring as to how to deal with a certain situation arising out of the pandemic. To take some very simple examples, you have, a contract maybe for the sale of goods or provision of services that simply cannot be performed because of an interruption in the supply chain or some other issue, physical issue that makes it impossible to perform the contract. That might give rise to a claim for damages, and obviously the party who wants to deliver the service or the goods would want to be exempt from any damages in those circumstances, might even want to be rid of the obligation altogether. Now, that situation can become very complex, of course, if we look at that contract in the broader context. Let's take, for example, a construction project. If the supply contract or the contract for services is part of a much bigger project, the consequences might be dramatic. What are the consequences for the supplier? What are the consequences for the owner? All those issues, and I'm reiterating here a point that John Marino, I think, made very, very clearly. One needs to go and look at the details of what happens in a given situation. One of our clients came to us. They are an operator of a power generator and distributor. So they have a wide variety of contracts. They have construction contracts for their various projects, and also all the contracts that go with the management and operation of a large power generating and distribution company. And they've been accused of being very inconsistent in rejecting some force majeure notices received and receiving others. And when one looks at the detail, in fact, there is no inconsistency. Why? Because in contract A, it might be correct that the provider, the supplier, was indeed prevented from performing by the COVID-19 pandemic or the various regulations and laws taken by governments in that connection. And in another contract, contract B, in reality, maybe the contractor, the supplier, whoever it is, was in reality not prevented from performing. So the notion that one can sort of come to a conclusion that for a whole group of contracts or a whole industry or whatever, there is or there is not an event of force majeure is obviously very, very wrong. To take another example, we've been consulted by the concessionaire of specialized airport management services. Needless to say that that's not a nice business to be in these days. Unfortunately, that company's revenues have gone down to approximately zero, while at the same time, their costs remain pretty much the same as they would if they were in full operation. So they have a concession agreement granted to them by a state authority. They are wondering what to do. Do they still have to pay the the concession payments due to the state authority every month? On the contrary, can they actually claim that this event is a risk event that weighs on the grantor, and therefore that they not only have no obligation to pay anything, but in fact that they might be entitled to compensation? And of course, the answer is that it will depend on the language of the concession agreement and possibly on the statutes under the applicable law. Before I go on, a last thing I want to mention, what we see here in terms of reactions to the pandemic is also some opportunistic behavior. And I'm not criticizing anyone here. At the end of the day, companies find themselves in difficult situations and are doing their best. But we do see some players who are objectively not prevented from performing, but are keen to use the situation in order to get out from a possibly money-losing project. And of course, that's an entirely different issue. And that, again, goes to the importance of pinpointing what are, in specific circumstances, the impact of the COVID-19 pandemic. Has that pandemic indeed caused a difficulty or an impossibility to perform? So if we look at that variety of different situations, what are the remedies that different economic players might want to find? Some might be interested in having their performance suspended. Others would want to renegotiate their performance in order to have more money, in order to have more time, in order to have different terms generally. And some, of course, will want to actually have their contract terminated and just be rid of the whole thing once and for all. And so it's interesting, of course, to go and look at the legal means of achieving those remedies in the different legal systems. And we've already heard a lot about this from the different speakers, and you'll be, I'm sure, interested to see that what we're going to say is not fundamentally different from what's been said by others today. If we look at the different options available, here they are. Force majeure, of course, is the main one. I also wanted to focus on a provision, a change of law provision that is sometimes found in some contracts, which can be very, very relevant here. Civil law systems have a particular concept of hardship that I will spend just a few seconds on in order to flag it, should it be relevant to any members of the audience today. Frustration, also, of course, a common law concept, is a relevant one. And fifth and last, some contracts, especially finance contracts, might have material adverse change clauses or material adverse event clauses, which I think can also be very relevant in these circumstances. So just a few words about force majeure, and I think everything has pretty much been said about this. When does force majeure typically occur? Well, of course, that will be a function of the definition of force majeure, which might be found in a contract or in some systems, and it's typically the case in civil law systems, in a statute. And I've put here what are typically, I've emphasized typically because we cannot generalize here the terms of force majeure statutes or clauses. We have the condition that the event be beyond the control of the contracting parties. I must say I much prefer the term unconquerable. I think that was an expression that we heard from Felicia, much more poetic. Maybe beyond control is a little bit more understandable to most people, but I sort of find an echo there in the notion that it cannot be conquered. I like that. Second condition, the affected party must be prevented from meeting the contractual obligation. And that goes back again to this theme that we're going to repeat over and over again, I think, throughout the presentation today, and as well as our panel discussion. That is an issue that needs to be checked, the causation in the specific situation. Final point, the event has to be unforeseeable and cannot be reasonably mitigated. Now, this concept of force majeure, of course, exists under both civil law and common law systems. A big difference, though, is that under, and again, here I don't want to generalize, which I'll say English law, and I realize that other common laws are different, but under English law, if you don't have it in your contract, well, then that's your problem. You need to have the force majeure provided for in the contract. There's no fallback position in the statute if it hasn't been provided for in the contract. So that's a point of particular intention. If one looks at French law, and in my experience, other civil laws are pretty much the same, there is a fallback position under the civil code or relevant statute, which can be, of course, a saving grace, especially in the case of contracts that have not been drafted in a very precise fashion. One point to know, though, is that the statute generally cannot be used to save a poorly drafted clause. In other words, if the parties have drafted a clause, they are stuck with that clause. The parties are free to go and define, or rather redefine, force majeure the way they want. So if they have chosen in their contract a particularly strict and narrow definition of force majeure in which the current situation is not included, then going to the statute will not help. They will be stuck with their narrow definition. What are the effects of the force majeure clause? And that's been discussed fairly extensively already. It's not a get out of jail free card. No, the solutions will be much more specific and granular depending on the situation. And again, of course, the drafting of the contract if there is a relevant clause. Outright exemption from performance is a possibility. Suspension of performance is another. Extension of contractual deadlines is also a possibility. Termination, in my experience, would be the exception rather than the rule. looking at the specific situation here with COVID-19, I think one can only say that it is necessary to go to the specific language of the contract. And I wanted to give an illustration here which might be of interest to those members of the audience who are active in the field of construction. I've had an issue under the latest edition of the FIDIC Yellow Book contract, which defines, they don't use the expression force majeure, the expression is exceptional events, but it's exactly the same concept. And there's a long list of events, none of which really allow the inclusion of the current pandemic. We're talking about war, we're talking about radioactivity, we're talking about terrorism, etc. But there is one, the last item, that reads natural catastrophes such as earthquake, tsunami, volcanic activity, hurricane, or typhoon. So I like the natural catastrophe. I think anyone can make a pretty convincing argument that this pandemic is definitely a natural catastrophe. By contrast, I don't love what comes after.
Charles, I'm sorry to interrupt. I just want to inform, like, we have 10 minutes for you and Zehan before we jump to the discussion and questions. So,
Thank you, Manu. Thank you very much for the reminder. So I like those words natural catastrophe, but then such as earthquake, tsunami, volcanic activity, hurricane, or typhoon defines a type of event that is rather different in nature from the pandemic. So certainly there is scope here for argument, but I wanted to mention this clause as an example of the type of discussion that can be most interesting for lawyers, of course, but of great practical significance for economic players. A quick word about change in law. Typically, the change in law will be available, of course, if there is a relevant provision to that effect in the contract at issue. And I think it was John Marino who mentioned that one needs to distinguish between the pandemic itself and measures that might have been taken by governments in terms of fighting the pandemic. And indeed, I think in most situations, what is getting in the way of contractual performance are measures taken by governments, such as health and safety regulations, confinement, interruption of supply chain, etc. Now, that does not mean, of course, that somehow that displaces the relevance of force majeure, not at all. But if there is a change in law provision of contract, I think that offers potentially a second bite at the apple. In other words, an alternative route or an additional route to relief, if that is at all relevant. I won't say any more about this. If it is of interest to anyone, obviously there's a little more information in the slide, but that is something that is worth, I believe, flagging. Here again, of course, the language of the clause will be absolutely key. A few seconds only on the civil law concept of hardship. In the French expression is imprevision, imprévision. This can be helpful in situations where the performance of a contract becomes excessively onerous because of a change in balance in the contract as a consequence of a change in circumstances. Again, this usually will probably be available in addition to force majeure. It might be a second or possibly a third bite at the apple, but it is something of potential interest to members of the audience who are involved in international contracts governing the law of a civil law country, because this is relief that might be available under the relevant civil code or statute, even though it appears absolutely nowhere within the four corners of the contract. So it's worth raising the question potentially under a contract governed by civil law. I now hand over to my colleague Zehan. Zehan, you're on mute.
Manu, do I have about 5 minutes under your supervision?
Yeah, around 6 to 7 minutes you have.
All right, thank you. So as the last batsman in this innings, I'm going to try and up the strike rate a little bit so that we leave enough time for the panel discussion. As Charles introduced me, I'm Zehan and I work with the Paris Arbitration Group. I'm from India, so welcome to everybody from back home, but confined in Paris. So the next topic that we have on our slide is frustration under English law. Now I won't repeat everything because Yao already covered a lot of it with some nuances under US law, particularly where she practices in Los Angeles. She said that these nuances included there should not be a difficulty in performance. Performance should not become more onerous, more expensive. Points that were also touched on by others, Felicia, Anuradha, etc. So long story short, under English law, the position is that firstly, frustration can be invoked if there is no force majeure clause in the contract. So of course, if there's a force majeure clause, then you cannot fall back on the doctrine of frustration, number one. Number two, frustration means that the contract becomes absolutely impossible to perform, i.e. there are no other alternatives, you've been backed into a corner, and there is no other choice. So just because performance becomes more difficult, more expensive, or more complicated does not allow you to excuse yourself from performance. Now, having touched briefly upon frustration under English law, the next topic I think is a slide which is basically a flow chart that sort of integrates everything that you've heard from all the speakers up till this point in time, which is force majeure, frustration, hardship, etc. The reason we came up with this flow chart, and by no means are we trying to generalize, as Charles pointed out, each situation is case specific, but this is just a takeaway for our audience members, which is that first you need a trigger event, such as the COVID-19 pandemic, or for fans of The Walking Dead, a zombie apocalypse. Hopefully that is not upon us anytime soon. So you need a trigger event such as the COVID-19 pandemic. You of course need a contract. And once the trigger event occurs, you need to go to the language of the contract, which is the first important step, which Charles spoke about. And that language allows you to assess, is there a force majeure provision or is there no force majeure provision? If there is a force majeure provision, then of course you take a deeper dive and you examine whether specific events like a pandemic or an epidemic or diseases are covered. And a good example of this sort of situation would be the Friedrich Yellow Book example that Charles gave, where none of this is covered, but there could potentially be room under the natural catastrophe clause to cover such a pandemic or a zombie apocalypse. Of course, if there's no force majeure clause, then the next step that you would look at is what is the applicable law of your contract? Do you fall under common law or do you fall under civil law? That will allow you to assess what options you have in terms of remedies in order to achieve certain legal means. And in order to do that under common law, you would have recourse under the doctrine of frustration, and under civil law, as Charles explained, you would have recourse under the doctrine of hardship. Now, in terms of what are the requirements of each of these doctrines, they're up on your slide in the tiny boxes, as also the individual slides. So I don't want to repeat them and take up your time. With all that said, I would basically like to conclude from what all the speakers have said so far, which is that the COVID-19 pandemic is a jurisdiction agnostic event. It has more or less affected all jurisdictions. It is also a sector agnostic event in the sense that we've seen an impact on construction, we've seen an impact on oil and gas, as Piyush talked about briefly, we've seen an impact on banking and financial services, technology, and all other broad baskets of sectors that we could think of conceivably. So it affects us all equally. But naturally, as John and Yao and others have pointed out, what needs to be assessed and is fact specific is, are we talking about the pandemic itself? Are we talking about the government response to the pandemic? Or are we talking about the consequence of both the pandemic and resulting government response? So with all of that said, I would like to now hand over back to Charles, who will give you some best practices and good housekeeping tips if you're involved in a project as a client or a lawyer or a contractor in terms of how to deal with questions arising from the COVID-19 pandemic. Back to you, Charles.
Thank you, Zehan. And I think what I'm going to say now really echoes what's been already mentioned by other speakers. But with a focus on international contracts here, certainly the situations are as diverse as there are international projects, but there is an added layer of complexity which really justifies, I think, a proactive attitude. I think waiting for the notices to come, and many have certainly come already, is in most situations probably insufficient. Looking into existing important contracts, identifying what might happen and anticipating what might happen, obviously for those contracts with high stakes, is certainly advisable, and that's what we see a lot of our clients doing. Monitoring, obviously, in those various international jurisdictions of relevance, what the governments are doing is certainly very helpful. And as I think was mentioned by Felicia, going to the contract and already looking ahead to the dispute resolution mechanism is also important. At the end of the day, a contract is only worth as much as its dispute resolution clause, because without that, it really is only a piece of paper. One important point I wanted to mention, because this is an issue that we're seeing a lot, I mentioned in my introduction that we are seeing a lot of opportunistic behavior. And again, I certainly don't want to criticize anyone. Each economic player must manage their business in the way that makes sense for them. We have seen, though, parties being tempted by opportunistic behavior. And my firm belief is that such opportunistic behavior, once it actually is uncovered, will be, I believe, very seriously punished, sanctioned by courts and international tribunals alike. So that pain might only come months from now, and the risk might be worth taking. Again, that's not for the lawyer to decide, it's for the party. Nevertheless, I think one needs to be very, very careful about potential abusive breaches of contract. And I want to end with an unashamedly self-serving recommendation, self-serving for the legal profession, of course. In an instance like this unique situation, getting legal advice before acting is an absolute must. We are seeing big mistakes being made, some of which are extremely easy to avoid by getting the right information, the right advice before taking drastic decisions. Thank you very much. That closes our presentation. And of course, we very much look forward to questions from the audience and to participate in the panel discussion.
Thank you, Charles. Thank you, Zehan. Thank you very much for all your insights, and thanks to all for their sharing their views. I think almost all the jurisdictions have same provisions and challenges to deal with these issues posed by COVID-19, whether common law or civil law. They all are in midst of a kind of crisis, I would say. What I can sum up in like just 2 lines is that to deal with this kind of issue and to deal with the force majeure issue, the details are very important to understand, as like performance is delayed, performance needs some more like inputs from one party, or performance cannot be like it's a non-performing thing. And also it's very important from the side of government, if we see that the measures taken to prevent the spread of pandemic, like it's very important, because if it covers the whole country, then it will be a very public health and a global health crisis, which it is currently. So it's very important for a lot of jurisdictions, I think, to work upon, and I think discussions like these serve a lot as a solution to this. I had like 4 or 5 questions in the beginning on which I would like to have your views and answers on that, but I think most of them are covered, so I don't need to respond them. And thank you so much for the brilliant presentations, all of you. I have like 3 very, very brief questions, and I would like to request you all to give brief insights on that, and then we can have the questions from audience, because they are also very important. As we know, like these the force majeure clause in the times of COVID-19 is creating a lot of issues between the parties and under the contracts. I want to know, what are the major abuses of force majeure clause that you all are seeing in these current situations, like the major abuses, with examples or something like that you can give? Any of you? I think we can start with the Indian team. Anuradha, Piyush. Can you hear me?
Yeah. See, the situation in India right now, as you're aware, is so fluid, as because the consequences of the lockdown are still not fully on the table. The problem that is being faced is that it's not that the lockdown has caused the end of the contract, but it is resulting in effects which will not be fully measured or evaluated for at least 6 to 12 months. And what we are looking at is that the lifting of the lockdown will not occur immediately. It will be staggered, and then it will be imposed again depending on how the classification of the district is undertaken. So for example, a district may be green today and everything is allowed, and it could become red within 2 weeks, and again you're facing situations where you cannot undertake certain activities or all economic activities. And therefore, the consequence is not only if you are present in the district, but also if your supplies are coming from there, or if your movement is stopped because you are you are beyond the red district and you are not being permitted to put in your equipment or bring your manpower. And therefore, in India at least, it will take some time for the effect to come through. And what parties are dealing with are contracts which say, unless you immediately notify or put up in advance the force majeure effect that you expect to be facing, it will not be a valid force majeure. So a lot of notices that are being issued are in response to specific provisions of contracts which require parties to even issue immediate notices on expected force majeure and not just immediate force majeure. So I wouldn't call them abuse as of now. It will only emerge after all the circumstances are seen as to how the updates are received, how the party says that it is being impacted. That should be the abuse. Maybe if a party undertakes to immediately reject offhand without asking for more data or without considering what the exact situation on the ground the counterparty is facing.
Thanks, Piyush. Anuradha, I would like to understand from you, like, is the force majeure clause, especially in this current situation, is it like, I think, a kind of weapon to get out of a bad deal? So are the companies, parties also thinking about this, like using this force majeure clause to get out of a bad deal they have entered in previously?
Yeah, I think just to add on to what Piyush said, the answer really lies in the fact that we really face with a situation where no party is unaffected. So it's technically an act of God which everybody is impacted with. So at this stage, to say that could it be subject to abuse? As Charles said, yes, perhaps it would be, but it's perhaps premature to kind of say that this could be a mere excuse to get out of situations. And I would say with reasonable confidence that our jurisprudence on this is fairly clear, that if the facts emerge at a later point of time that the sole reason was to use COVID-19 as a convenient excuse, it's very unlikely that a party would be able to succeed. The burden of proof under Indian law is fairly high, and so it really depends on, in terms of the facts and circumstances, the actual provisions and terms and conditions of the contract that we are dealing with, to be able to come to that conclusion.
So according to you, the jurisprudence is strong and the judicial measures are strong, so that the abuse can be prevented in such ways, right?
The abuse can certainly be prevented, but I would say the jurisprudence has to evolve because the precedents that exist as of today in themselves may not be sufficient to address the unique set of challenges that this event has presented.
Sure. No, I'm really sure that discussions are like these are also addition to the jurisprudence, and obviously these will be helpful. Thank you so much, Anuradha. Felicia, my next question is to you. Like, as you are leading a dispute resolution team, I would like to ask, like, very briefly, what is the dispute resolution mechanism? Because if the party is not performing it, and as we all heard that there are no clear provisions, so they might end up entering into a litigation, filing a suit. What are the best measures of dispute resolution mechanisms that parties can follow to deal with this kind of issue? Very briefly.
Very briefly, well, a starting point, and I will repeat, in Singapore, the position is very much contract-based. So the dispute resolution mechanism follows what was in the contract. The only difference would be if they were trying to use the act I mentioned earlier, the COVID-19 Temporary Measures Act, then the resolution mechanism is built for statutorily, and you've got to go to file a notification. It's then determined by an assessor, so there's no cost to pay, or it's nominal. It might be like couple of $10 or something, and that would then be determined by the assessor. So it's a very quick process. But I think one something I'm noticing is that in the past, if you had a difficulty in your business for whatever reasons, you might delay in payment or performance of certain aspects of the contract, the monetary aspects, and the innocent party would threaten insolvency type proceedings, send you a statutory demand because that sort of gets your act together, and then you might pay them first because you tend to pay the most aggressive creditor first. Now, because of the act that we've got in Singapore, in these 6 months, any statutory demand that you issue, which only needed a 21-day payment period in the past before you institute insolvency proceedings against a company or individual, now you've got to wait 6 months. And note, it doesn't mean you wait just from April to October. Any demand you issue within April to October, you wait 6 months from the date of issuance. So technically, you could end up waiting till April next year before you could actually threaten insolvency, realistically. So one thing I'm seeing is whatever the conventional dispute resolution mechanism might be, you've also lost one of the weapons that contracting parties used to use as a strategic way to bring someone to the table. So it remains to be seen. I mean, I'm with Anuradha on this because it's so early days, although it feels like it's been very long for most of us who've been locked down for weeks. But it's really fairly early days when you look at jurisprudence as to whether the conventional contractual dispute resolution mechanism is maintained or some sort of third or unique creation has to come up to deal with things where you can't really have the old ways. Anyway, I'll leave Charles to describe what's happening in arbitration. I hear there's a lot more of arbitration still going on, but it's very much all done via Zoom or the way we're having our webinar now. And I'm hearing it's very difficult to take evidence, but that's a side topic.
Thanks, Felicia. Thank you so much. Now from John and Yao, we were discussing about the definition of the force majeure, and we got to know that there is no set definition in any of the jurisdiction or any of the jurisprudence. So what we can expect from the legal community of the entire world, like whether we will be seeing a definition which will be covering or which will be suitable for all jurisdiction and all type of issues, whether we should be waiting from a multilateral institution or a tribunal or someone to set a precedent to come up with a definition. What are your speculations on this? Very, very, very briefly. Thank you so much.
So asking us to predict the future seems like it's a tough question. I would expect that in the US, the courts will not be looking to a multilateral organization to defer to them whether the business disruption is actually caused by covered by a force majeure provision. I think it's going to be entirely localized for the US. I think that there's going to be some courts in certain jurisdictions that read things very broadly, and I think that there are other jurisdictions where it's going to be read very narrowly. A lot of it, because of that's the reality when it comes to US local law, there's going to be an advantage for parties who are dealing with courts to choose their venue and their jurisdiction. Because if one party is going to go to a jurisdiction, they're going to want to go to a jurisdiction that they are comfortable in. It's their home base to get the benefit of the doubt, and with the expectation that the triers of fact, whether there is an arbitration panel or whether it's U.S. judges, federal or state, they're going to be more experienced in what businesses were undergoing in those moments when these disruptions applied. And so it really may incentivize companies to go to their local jurisdictions because they will have the most experience in what the true effects were in the moment. we'll see. So far in the U.S., the disputes that have been formally filed had to do with breakups of proposed combinations. Those are the disputes that are actually taking the formal steps so far to go into disputes. The ones that are more contractually based, where there's going to be an ongoing relationship between the parties, in those instances, what we've seen so far is the parties trying to work out how to get to resolution, short of filing an arbitration demand or filing a case in court. The one other thing I wanted to mention regarding your question about abuse, the abuse that we've seen thus far has to do with international contracts. Certain parties in certain jurisdictions taking advantage of what they believe is a lack of knowledge about that jurisdiction. So we have some clients who are coming to us saying, okay, we're based in the US, however, our counterparty is based in Asia, or is based in Europe, or is based in South America, and they are claiming force majeure, saying they can't perform under this contract. And they're expecting that the US entity will defer because they're the locals on the ground in that particular region of the world. What we've noticed is once we've done a little digging into that claim of impossibility to perform the contract, it's actually not what's being claimed in their notice. So we really think it's incumbent upon the parties to get localized knowledge and to consider what's actually being experienced by the counterparty, because unfortunately there are parties who are taking advantage of what they think to be ignorance. And so it's really important to dig into those details to find out what's real and what's just being alleged.
Sure. Thank you so much. I was about to ask you about the venue and jurisdiction considerations you already mentioned. Thank you. Zehan, do you think could be the possible reforms in business interruptions and disruption contract clauses, obviously for which force majeure is a clause? So what could be the possible reforms around the world? Very briefly.
Well, I think the main thing, Manoj, is the drafting of the clauses. What parties are realizing as they nervously open their contracts and look for the clause is that they too often find clauses that are inadequate and don't give any certainty one way or the other. And that uncertainty is, of course, what then feeds into poor relations between the parties, because it can drive one party to a certain interpretation which the other party will not agree with. And so what we're going to learn is that the clauses should be drafted in a way that is that covers events like this. Then what will the next event be? We don't know. But I note, for example, that the ICC, the International Chamber of Commerce, has put out a new model clause, which I have to be honest, I haven't at this stage focused on much. I think it's probably coming a little bit late in the process, but they've been working on it for some time, to be fair to them. So that's interesting. And that certainly is also what we've seen from some clients. They tell us, what sort of clause should we put in our new contracts? So I think the focus is very, very much on drafting clauses that are adapted to deal with circumstances like this. Not only in terms of defining the event, but also possibly in terms of the consequence of the event.
Sure. Zehan, would you like to add something?
I would just echo what Shah has already said. So in that sense, I don't have much more to add, but I will definitely take on one question that Felicia raised before she finished, which is about what is the outlook in the arbitration community in light of this pandemic. So what I have to say on that is that unlike national courts, arbitration is something that is free from bureaucracy per se. So we don't need too many meetings and resolutions to sort of brainstorm and find solutions as to how to continue doing business as well as continue to promote the cause of arbitration. So to that end, to take an example from what Felicia said as far as virtual hearings are concerned, all the leading arbitral institutions have put out a thought leadership piece on 16th April, which I invite our viewers to check out, where the message that is being sent out is that if your contracts have arbitration clauses and if you need to file notices, etc., please consult your legal advisors. The institutions are open for business. Everything has now moved from a paper-heavy universe to a largely paperless universe. Filings of notices, etc., are happening electronically. And for those that are concerned that they will not have their day in court, I think arbitration has always sort of led the way in terms of embracing technology and setting new benchmarks. So we continue to use technology such as Zoom or other such platforms in order to facilitate virtual hearings. Of course, recognizing that there are certain challenges for taking evidence through these platforms, but we're all learning as we go. And the message that we would like to give is that arbitration is definitely ready and well equipped to assuage these concerns and ensure that justice is neither delayed nor denied. So that's all I'm saying.
Sure. Thank you, Zian. Thank you very much. And I think I'm about to enter into a cross-border contract and agreement with an organization in the US, and I think I've got a whole panel of people to advise me what I have to draft in my contract. So I'll look out to you guys whenever I'm entering into that agreement. Thank you very much. Now I would turn to our colleague from ILI, Robert Sargent, who would be moderating questions. I think we only have 10 minutes. So Robert, like if you take 2-3 questions, and then I'll end the webinar, and then we can have the question and answer answered after this, and then we can post it with the video. So over to you, Robert.
Okay, great. Thank you very much. And thank you for all of our speakers. We have one question that has come up in a number of different formats. I'm going to ask if Andura might be able to field this question. This has to do with the effects of landlord-tenant contracts and rents in terms of notice and provisions ending tendencies and recovery of arrears in rent. Essentially, the relationship between the tenant at this point and the landlord, and what are the rights and obligations thereof under the COVID situation.
Robert, did you direct that to me? Sorry, I missed that.
Sure. The question in brief is, especially in India, the commercial application of the relationship between the landlord and the tenant in under the conditions of COVID. What are their obligations and rights?
Yeah. So the simple answer to that is that the terms of the contract would be paramount. And in our practical experience, lease agreements very rarely provide for force majeure situations unless they have been extremely carefully structured and drafted. So in the absence of a specific provision on force majeure in the agreement itself, if the fallback is frustration, the remedy that a party is looking at is then, rendering the contract itself void, which perhaps may not be in the interest of the party itself. So unfortunately, in a situation of rental payments, there is no blanket, excuse for non-payment. But perhaps given the set of scenario and circumstances, it makes sense for parties to renegotiate this aspect itself. And this is where another, in the example of the Singapore situation, where Felicia was mentioning, as far as commercial rentals are concerned, I understand that the law itself is providing for a leeway from any kind of damage payments for non-payment of rent.
And similar, if I could follow up, there's a question that with respect to India and more specifically construction contracts, how would force majeure work because the rents of the equipments become due?
Piyush, you want to field that?
Sure. The issue on the rent of construction equipments, again, this will be dependent on the terms of the lease agreement for the various equipment. But if there is nothing relating to a force majeure in your lease agreement, it will have to be looked at as to whether there is a case for frustration since the equipment has not been put to use for the purpose for which it had been leased. But that again will depend completely on the paperwork or the communications between the equipment provider and the contractor, and furthermore the contractor and the principal employer. And therefore, it's not a generic question which has in any manner a generic response. But again, the terms of the contract, and in the absence of the terms of the contract, the communications that have gone back and forth between the parties would be paramount.
Another question specific to India is, in Indian context, who should be held legally liable for this crisis? Is it the parties concerned or the government for imposing a lockdown without giving some time for the parties to prepare?
No, so there's no legal responsibility as such, because it was an action taken by the government under public health under specific laws. And therefore, it will have to be dealt with under the contractual framework for the commercial transactions. However, if the issue is relating to whether the lockdown was legitimate, that is an issue to be filed and debated upon under the courts later, which I don't expect Indian courts to really go into, although there's this huge ongoing debate as to whether the Disaster Management Act was meant to declare the whole of the country as an affected area or not, since it only deals with localized or local disasters. But then that is an issue that will have to come up through the courts under its jurisdiction. It's not something that can be gone into by lawyers as such.
Okay. I have one comment and one last question. For those individuals who are asking to see the slides that were presented, this presentation will be available on the INALP and the ILI websites for further review. So if you've missed the presentation or parts of it, or went by faster than you had anticipated, you'll be able to look at it on our websites in about 2 days. And I think if anyone wishes to direct any emails to me or the speakers, we will coordinate to see if we can't get copies of those slides sent to you. My name is Robert Sargin. My email address is rsargin@ili.org. And my question for John and for Charles, and Felicia, if you can maybe ask or provide some sort of feedback quickly. What are the law firms now thinking about doing in your discussions, in your internal discussions, about looking at revamping contract clauses across all industrial and commercial applications to account for similar issues moving forward?
So we're dealing with this literally. I'll deal with this later today. I was dealing with this yesterday. We are working with clients regarding changing the clauses to capture issues such as putting in provisions like whether the event is foreseeable or not, because clearly if it's required to be unforeseeable and you're signing a contract today, you can't say it was unforeseeable that there would be a pandemic, there would be COVID-19. So that clause means something very different today than it did 9 months ago for sure. We're also considering the parts of the provisions that talk about whether the catch-all phrase in a force majeure clause should be read in such a way that the catch-all still has to be like an event that's listed in part of the litany of events that it's being listed, or whether it says like these other events that I've mentioned in this clause, or doesn't have to be like the other events that's being mentioned in this clause. So these are practical tips that people are considering when they're executing contracts right now, or they're considering whether to execute amendments right now because they're taking new orders on things. And so these are absolutely issues that clients are grappling with in the moment, and will be, frankly, sophisticated companies are going to be thinking about their clauses, whether they're the force majeure clause, whether it's a material change clause, whether it's their warranties and reps. They're going to be thinking about all those things in light of what we're undergoing and tweaking their contracts going forward, frankly, under law, you're going to need to if you're going to want the protection of that clause regarding a pandemic, because if you're doing it going forward, everything has changed and context very much matters.
Okay, thank you. Charles, did you have any comment?
Yes, just to add briefly, I think the approach at our firm is more of a bottom-up approach. In other words, learning from actual matters handled. Most of the work we do is really bespoke. We don't have an official force majeure clause or a collection of official clauses. Of course, the firm, different practices within the firm have templates that they use, but will usually adapt to given situations. And those templates undoubtedly will be updated based on that bottom-up approach. But the first thing is we are listening to the clients coming to us, to their needs, making sure that contracts they sign today going forward are adapted to the current circumstances and what might happen in the future. And then that feeds, of course, that case-by-case experience then feeds into the collective knowledge of the firm that will be reflected in the templates that are updated on a constant basis.
Okay, thank you. And Felicia, you'll have the final say, and I'll turn it back over to Manuj.
Right. I think likewise, our firm also built on, I guess, learning points from clients' actual cases. And I'll just cite two examples, one of which I think is very similar to the FIDIC example Charles mentioned. So natural catastrophes, or without the word natural, just catastrophe, is a fairly common event seen in force majeure clauses. And sometimes there are illustrations to explain what is included in as a definition of a catastrophe, using words such as earthquakes and all. And there are also cases where you include exceptions, what is not a catastrophe. So we're seeing clients, depending on which side of the scale they expect or foresee themselves to be on. Some have asked that such events be included as some sort of catastrophe or disaster that would be a contractual force majeure event, while others have wanted it to be expressly excluded. I think you know which side you fall on when who wants what. So we're learning from that. But the other thing we're also seeing quite interesting, which I sort of, so this circling back to my earlier presentation would be, we always look at leases as a conventional type of agreement, but in Singapore, and I'm sure in other jurisdictions as well, quite a significant percentage of our commercial leases are now for with co-working entities. And a lot of the contracts are co-working space contracts. So there is an ongoing analysis, not just in my firm, but across quite a few firms in Singapore as to how you deal with them. And some of these, what I call landlords, but they don't consider themselves landlords, are re-looking at their contracts to make clear that for whatever reason, whether you blame the government for the lockdown, even if you can't occupy the space, your obligations in the contract remain unchanged. So those are a few things that we just learned.
Okay, thank you. And Manuj, I'm going to turn the program back over to you.
Sure. Thanks, Robert. So thank you very much to all the speakers. We are talking about disruptions and interruptions. I think we have disrupted and interrupted a lot in Yao's and John's breakfast time, Zehan's and Charles' lunch time, Anuradha's and Piyush tea time, evening tea time, and Felicia's dinner time. So apologies for that, but thank you so much. We really appreciate your time, and thanks for sharing all the knowledge and insights that you did on the topic. And thanks to the wonderful audience for patient hearing, making this session more intriguing and interesting by their questions. Thanks to the team of ILI and NAL in both Washington, DC and in India for all the technological and logistical arrangement, and particularly on behalf of INALP and all of you, we would like to thank ILI and in particular Mr. Robert Sargent for being very instrumental in doing all this and arranging this. ILI and INALP will be partnering more and will be coming up with more discussions, important discussions on topics like this. The next one that ILI is planning is on international bankruptcy, rights protection and restructuring, where lawyers from various jurisdictions like this panel will be participating. Few governments will also be participating, and keep an eye on our websites and social media for the updates about that. The recording of this webinar will be posted on the website of INALP and ILI and the social media portals. So if you want to share with your colleagues, feel free to do that. I hope this webinar was informative for all of us who attended. For me, it was very much informative, and I'll be very careful about drafting our contracts and all. In the end, I wish you and all your families a very a very safe and good health. Thank you so much, and have a great day or good evening, whatever you are going to do. Thank you. Bye-bye. Take care.
Thank you,
Thank you,
everybody.
everyone.
Thank
Thank
you
you.
very much.
Stay well. Thank you.
Thank you.
Thanks, everyone.
Thank you.
Bye.
Bye. Thank you.